次に高島先生。
Next, let's invite Mr. Takashima. So Mr. Takashima, the floor is yours. Thank you very much for your introduction. My name is Takashima. Like Mr. Shimura, I focus on civil code, and at the same time, I also focus on consumer law as well. So there is a qualified consumer organization certified by the government. I'm also one of the head of those organizations. So speaking of a certified consumer organization, when a company does unfair activity, so we can stop their activities. So those organizations have been given by law to stop such unfair activities. And belong one of the Kyoto Consumer Network, that is the most advanced group as a certified consumer organization. KDD, Selemar, and other major companies are our target for legal litigations. And we have been quite successful with the litigation with those major companies. So taking one of the examples, so what can we do to control powers by the central government, by the citizens? And what's the necessity to do that? So that's my whole point of this presentation. I have only 20 minutes. Let me just proceed. So this is agenda. First of all, let me just cover the objective of the report. And then I would like to talk about the necessity and the current situation of the power control by citizens. So what kind of legal frameworks have been available at the moment? I'll just leave it answer. There's only insufficient structure, but still, there are some systems that's working to produce some tangible results. There are two major frameworks. One is citizens or residents can control fiscal situation of the local communities. That is a resident audit request and also citizens lawsuit. And I just mentioned earlier, consumer group lawsuit. So there's a framework called consumer group lawsuit. So consumer group can sue the companies who are engaged in unfair activities. So based on those two schemes, in order for us to improve or expand the scope of citizen-based power control, what can we do? What are the necessary things we have to tackle going forward? And in conclusion, I would like to touch upon future steps and what will be the outcome for the future in this area. So first, the goal of this presentation. So the first question, why do we have to have the citizen power control? Well, needless to say, as Itoga-san said earlier, well, the government ignores the laws sometimes. And also the same goes to companies. They try to avoid responsibilities. Or some specialist group, they just use the favorable opinions to them. So the control system itself is, of course, necessary. That's absolutely true. But let's take a closer look at the situation. So when we say power, let me just define the power. So citizens as opposed to citizens like ourselves, central government, local governments, and big companies, including mass media. And on top of them, they are not always incorporated, but like doctors, organizations, or lawyers, associations. So there are some specialists or powerful specialist groups. So what's common among those groups? As Ms. Aihara said, knowledge, know-how, economic power, and negotiation power. There's a disparity of the gap between citizens and also those groups. There's no replaceable situation. So if we can replace the situation, then we understand other situation. But since citizens and state situation cannot be replaced, so if one becomes a victim, then they have to continue to be a victim. There's no way they can win. So then for those powerful powers, what kind of control system has been put in place? Well, there are quite a lot of systems available, but well, there are some systems that function to some extent, others are not working at all. So there are several systems that works quite okay. So let me just look at two systems that's working okay at the moment. And like I said earlier, what are the necessary factors for us to have for the future system? So the factors that we need for the future system are four things. One is a lot of citizens can't use a system, and the system excludes a conflict of interest in its system. Next, a system establishes the economic foundation for the users to use the system. And also, there's a chance of abuse of system. So there is a mechanism put in place to prevent misuse of the system within the system. So next, let me talk about the necessity in the current situation. Why do we have to have a control of power? So looking at the modern society, well, all the systems have become more knowledge-based, more advanced technology-based, and more sophisticated. So even with the government or the companies or doctors associations, it's not that they have all the necessary knowledge within the organization. So there has to have the division of labor. If you look at the nation or the companies or doctors association, particularly looking at the company, the administration has become so bloated. So separation of powers fails to work at the moment. This hasn't really been pointed out. That's very important, actually. So I'll cover the details on the next slide. So as for companies, needless to say, they just focus on the pursuit of profit. That's all they have. Well, since companies are incorporated, there is a corporate law or act. So within the corporate act, there is no mention that the companies have to work in an ethical manner. If there's a victim due to the company, if the senior management said that let's sue ourselves, well, if it's not an unnecessary lawsuit, then they will suffer from a class action by their shareholders. So there's no problem in terms of system for the companies. What about the specialist groups? Like I said earlier, well, there's a lack of autonomy for those groups. That's important. Let me just go into the details in 2 slides more from this one. So what's the current situation? Like I said earlier, there are some systems that's working okay. So a typical example is a citizen's audit and also citizen lawsuit. Or there's a system to recall of mayor or governor Well, that's to some extent it's working, but there are systems that doesn't work at all. For example, we have the right to control the authority. For example, there's a judicial review of administrative deposition. Oh, sorry. Well, there is actually national examination of the Supreme Court judge. There was no judge who were deselected from their position. And there are other administrative lawsuits. Well, there is an administrative lawsuit act. So there's a system that allows citizens to sue the administration for their mismanagement. Well, there's a limitation to that. So first of all, we have to claim that one's interest has been violated by the administration. We can't just sue the administration, just saying this is not right. So I have to prove that my own interest has been violated, and this has to be legal interest or legal personal interest has been violated. So with that, it's difficult to control the administration based on that administrative law. Well, there are some systems that's working okay, as Mr. Shimura said earlier. So claiming damage claim is one of the things. So that's actually after the fact relief. But what's necessary is a preliminary injunction before something happens. Well, that's actually not the case. Actually. So what we call injunction. So in the current legal system, it's not really well developed. So let me just cover the details for that. For example, what's most important for us? What is the most important interest is to protect our life and health. But in our legal system, so when our life or health is harmed to some extent, there's no legal ground that we can sue someone just because we are threatened by someone else. Do you know the copyright? So there are a lot of law articles to protect personal rights. Sorry, copyright has been protected. So, like I said earlier, separation of powers have failed to function. So that's a negative impact on the citizens. So the administration of bureaucracy have actually made laws, and they work as the court. So if you look at number 1, so as society becomes more advanced and judicial function requires a lot of knowledge, well, it's not that the Diet members have all the necessary knowledge to make a decision. When they make a law, or don't have enough knowledge, so they just rely on bureaucrats, and they just prepare for the Diet members to come up with the laws. And the bureaucrats prepare the response document, and all the physical actual work of lawmaking has been done by the bureaucrats. Well, this was supposed to be done by the Diet members, but actually the bureaucrats are the ones who actually make laws on behalf of Diet members. We talk about the Nuclear Accident Child Victim Support Law. So they just indicate the principles only in that law. So in which area, what kind of person and what kind of support or relief will be given? There's no mention of specifics in that the child victims support law. So everything is up to ministerial ordinance or government ordinance, which can be made by the bureaucrats. So this is too vague. Well, sometimes it's necessary to have such framework-based law. As society changes, it's difficult to go through the diet sessions to modify the law. So the law should be just stipulating the basics, and the details will be specified in the government ordinance or ministerial ordinance. Well, that's the basics to come up with the laws, but unfortunately, this is not in line with the spirit of making laws. Well, I think intentionally the government created a nuclear accident child victim support law in such a broad sense without coming up with the details. Maybe I don't have to talk about the judicial function. Well, there is government notice within the government organizations. Well, this has no power, no binding power against the citizens. But since the government notice has been circulated within the government bodies, and the administration works based on the government notices, then the notices started to have binding power for the general citizens. So the government notice is just a letter of interpretation of the laws. Even this has not been approved by the court or the judges, but this has become a sort of social norm. Let me just talk about the specialist group. For the nuclear accident, specialists played an important role. As Tsuda-san indicated, doctors, epidemiologists, and other specialists have done review in their own arena. If we leave some of the social regulation to specialist group, well, as a assumption, we have to have some level of autonomy. Otherwise, there will be additional confusion, disorder brought by the specialist group, as there are opposing ideas among the specialists, so citizens are confused about which one they should trust. So even some of the specialists said this is the right opinion, but it's hard for the general public to tell that is the case. So once one becomes a doctor, there's no need to have a continuous education. If one becomes a doctor 30 years ago, they don't have to study at all. They can still act as a doctor. Or in the consumer protection area, well, they're not supposed to sell lighters without any safety function. So in the consumer protection area, to protect the consumer's interests, they are renewing the rules to protect the interests of the consumers. But some of the doctors still continue with a very old knowledge. What about the disciplinary system? Unless a doctor commits a crime, then they won't be discharged. And doctors doesn't have to be a member of Japan Medical Association. And there is no consensus building system for the group. And like I said earlier, even they belong to the same industry, same section, there's an opposing ideas. In 2013, there's a report issued by Science Council of Japan. And there was a recommendation done by Science Council of Japan to the Japan Medical Association. So at the last of the report, to realize the autonomy for the doctors, I'm hoping that this report will make a contribution. So meaning that So doctors have no autonomy. So this was clearly mentioned in the public arena. So I'm just running out of time. Well, this is actually the most important point. I'll skip the details. So there's a system called citizen audit request and citizen lawsuit. As long as one lives in that particular local government, so one can control the irregular or the unfair financial activities by the local government. Well, this has been quite utilized for 2009 until 2009 to 2009. There were 1,798 residential audit requests and also 692 resident lawsuits. So I'll show you the graph. There's a city called K. There's a mayor. So city is a representative person to do some transaction with other parties. So the mayor of K. Well, this is the example of Kyoto City. Tanabe-san is the mayor of Kyoto City. Well, Kyoto has decided no more golf links. But when the vendors said that we want to build a golf link, then Kyoto will buy the land to prevent that happening. So they struck a deal with the vendor who would like to make a golf link. But the land price is so expensive. So what happens is that, well, the land could have been bought at much lower rate. So due to the mayor, so the loss was incurred to the city of Kyoto. Of course, the right to the golf link is transferred to the city of Kyoto. So citizens of city K were not happy about what happened. So they can request to the audit member, but the citizens were not satisfied with the audit results, and they can resort to the residential lawsuit for the damages to the mayor of city of K. So the city will sue the mayor of Kyoto. So in this example, so on behalf of the Kyoto city, then audit members sue that mayor. So I just cited some of the details about the articles of Local Government Act. So the Tanabe-san, he or she was charged with 2.6 billion yen as damages payment.
So the earlier case was when the contract has already been signed. But if the contract is not yet signed, there is a allowance for injunction in order to prevent such situation, the signing of an illegal contract. There are some repetitions where same party keep submitting these injunctions several times per year. But in any case, in terms of increasing transparency of the finance of municipalities and local government, it has contributed greatly. In the past, in Osaka, there has been an abuse of public money and taxpayers' money, and this same system has been utilized in the same way. Now, let me talk about the consumers' activities and consumers' class action. Well, if a certain the consumers group, what we call the eligible consumers group, would be allowed to represent a class action lawsuits for certain activities by companies in terms of the illegal or inaccurate advertisements or labels or product labels. So this is quite an innovative system. The fact that one organization can counter certain activities of the government and actually override certain aspect of the activity of the government. This is quite innovative again. So, but in order to be eligible for the system, the Japanese cabinet prime minister has to approve officially such organization as an eligible consumer group. So, is this very much utilized today in Japan? This is a relatively new system, so therefore there are not so many existing cases. But as of 5th of July 2013, there has there has been 30 cases, and in total, without including those that did not lead to lawsuits, there are a total of 111 cases. The most recent and very known example among Japanese people is Rise Up. It's gym, sports gym, that has a massive TV commercial saying that they will full money back within the first 30 days. But actually, this was not a full guarantee because there were so many detailed conditions, and this was considered to be inaccurate advertisement, and was submitted as class action lawsuits by the consumers. Now, let me describe using this diagram how it works. So if the consumers signs a contract with a corporation that includes unjust article in the contract, then they can report that information to the eligible consumers organization and request further study or research. Having received such information from the consumer group would undertake research and directly contacts the company to request improvement or stop using the particular article in the contract. If they refuse, then they would go to the court claiming injunction. This is highly evaluated in Japan in terms of the impact it has had, not only in terms of the ex post relief of individual damages, it can prevent the overall abuses and damages inflicted on consumers as a group, and it can also apply injunction on corporate activities not only at the individual company level but also at the industrial level. And also the fact that there are so many various eligible consumer organizations, co-op, our organization, KCCN, and other consumer groups or consumer organizations, the lawyers associations are all backing up, not as an eligible organization, but they are supporting such system. That's an important factor. Also, the transparency of finance is very important, and yet another important element is the complete elimination of conflict of interest. And in that sense, this consumer class action has succeeded in completely eliminating the conflict of interest in terms of its system. No relationship whatsoever between the lawyer and the other parties involved in the case. And if there is any relationship, then it has to be reported each time. The voting rights are not given or taken away by anyone who has even minor conflict of interest. So going back to the transparency of finance, in case of our Kyoto organization, KCCN, we operate only based on the annual membership fee of 3,000 yen per member. And if there are any additional budget required for my activities, I have to pay out of my own pocket. The same applies to media. The fact that international internet web journal, the IWJ, is so well respected in the Japanese society is because they are functioning purely on the basis of the money, the contribution of the viewers. Now, I also would like to talk about the importance of the solidarity of the active relationship between the government and the citizens. For example, our organizations has generated, in terms of human resources exchanges, various important people such as director of the National Consumer Affairs Centers and other organizations. There has been such secondments. For example, the third director that was appointed by the National Consumer Affairs Agency was someone who had served as a Secretary General of the National Consumers Organizations Federation. So in any way, what I'd like to say is that the relationship is important, but at the same time, the clear lack of conflict of interest is important. You're not receiving any money from companies, so you can be free in their activity, but you also need the budget. Such dilemma exists, but these activities and these systems exist within such dilemma. I'm omitting many points because I'm lacking out of time, but actually there are areas where there is a complete lack of control method in terms of the system. For example, in terms of the judiciary, there is the supreme possibility for the citizens, Japanese citizens, to directly choose and audit the Supreme Court justice. The system exists, but it's not well designed. It does not function. Also, in terms of the legislative, same goes true that this is just on the surface that the citizens can utilize voting in election as an indirect control system to the parliamentarians. And that is not the case. Once you are elected as parliamentarians and diet members, there is basically no control. The chairman actually, of course, obviously has an important role of disciplinary power, but other than that, there's basically no system of control. So we need to really look into the current legislative system as well. But how about the government administration, the national administration? Well, we have the class action lawsuits. We have on a small level, there are many control systems, but does it exist in a much higher level as a national level? Can we undertake a class action lawsuits for the sake of citizens versus the government? This system does not exist. We need to be aware that such structure does not exist. If you actually look at the system, there are other countries like Finland and Denmark has the ombudsman system. Many other EU countries have ombudsman system, which means that a third-party organization, an ombudsman, can serve to counter the actions or the voices of the government, be it the legislative or the judiciary or the executive. Such system does exist elsewhere. So when you think about that, the system that we could currently use, there are at least two systems, the residence lawsuits and residence audit. We need to use these existing tools we have to exercise citizens' control. That's something that we should be thinking about. Thank you very much for your attention.
Thank you very much. So one question from the floor. Thank you very much. My name is Yoshida. As you said earlier, so the Child Victim Support Act. So who actually initiated in creating the Nuclear Children Victim Act? So what the background of this law was enacted? Can you elaborate on that point? Well, I don't know the details about the enactment process. I can't really be specific. Looking at the result, well, that was lawmakers led the laws. But looking at the substance of the law, there are a lot of advice from the bureaucrats and experts. So such a framework-based law would be modified by the ministerial ordinance or at the lower level ordinance. So there's no substance to that act. So I don't know why such incomplete act was actually enacted. Well, that was an intentional way of making the law like that. So who actually initiated that enactment? Well, at least, mostly the bureaucrats. I don't know if the DIET members are aware of how incomplete it is. Depends on the knowledge level on the DIET member side. Thank you very much. Well, this concludes the morning session. And